Hello, everyone, and welcome to my case summary on Romer versus Evans from 1996. This is a Supreme Court decision that has big implications for the 14th Amendment. And if you're in a constitutional law class, you probably need to know Romer versus Evans. So, this was an opinion by Justice Kennedy. It was 6-3, decided mostly along ideological lines. And basically, what it involved was an amendment to Colorado's state constitution known as Amendment 2, which banned all legislative, executive, or judicial action at any level of state or local government designed to protect gay people from discrimination. Colorado's state Supreme Court held that the amendment would be subject to strict scrutiny under the 14th Amendment because it was infringing on the fundamental right of gays and lesbians to participate in the political process. So, the Supreme Court, Justice Kennedy, who has a very pro-LGBT record, I would say. He went on to write Obergefell versus Hodges, although he was actually a fairly conservative justice overall, wrote that the amendment was unconstitutional. It withdraws specific legal protection from discrimination for gays and lesbians, but from nobody else. So it's singling them out. They reject the petitioner's argument that the law only functions to deprive gays of special rights because it imposes a special burden on those groups alone. It's not taking special rights away from them. It's just targeting them, plain and simple, and that's incompatible with the 14th Amendment. So the protections against exclusion that Amendment 2 withdraws are taken for granted by most people. This is something that most people who haven't experienced discrimination won't say that they have experience with, but then this amendment to the Colorado Constitution comes along and just throws gays and lesbians under the bus. So the 14th Amendment's promise that no one shall be denied the equal protection of the laws must coexist with the practical necessity that most legislation classifies for one purpose or another with resulting disadvantage to various groups or persons. Conversely, if a law neither burdens nor targets a suspect class, we will uphold the legislative classification so long as it bears a national relation to some legitimate end. So if it were more neutral, it could be upheld if there was actually a national relation to that end, if they were actually pursuing some sort of goal and they weren't targeting or privileging some sort of class of person. But here, they're just laying out a category of people and targeting that category of people, and that's why it's unconstitutional and needs to be subject to strict scrutiny first. So when they do strict scrutiny on it, they find that it fails it, because it's both too narrow and too broad. It's narrowly singling out the gay people by one trait, the fact that they're gay, and then it denies them protection across the board. This type of law is unprecedented, the court says. Colorado argues that the rationale for this law is to promote freedom of association and to conserve resources to fight discrimination against other groups. That's a very interesting reason. Amendment 2, however, is not classifying gays to further a proper legislative end, but to make them unequal from everyone else. It's basically implementing second-class citizenship against this group of people, and that's why it's incompatible with the 14th Amendment. Now, Justice Scalia, who is known for being very anti-gay, pens a dissent, and he's joined by Chief Justice Rehnquist and Justice Thomas. And he writes that Amendment 2 is just a modest attempt to preserve traditional sexual mores against a politically powerful minority. He says that the majority contradicted Bowers v. Hardwick. Bowers v. Hardwick, of course, upheld criminal statutes banning sodomy. It said that they don't violate the 14th Amendment, that they're perfectly constitutional. He says the U.S. Constitution says nothing about homosexuality, so laws on homosexuality should just be left up to the states. And this is a pretty common refrain for conservative-type justices in cases like these, in cases involving individual rights, rights for LGBT people, that, well, let's just let the states handle it. And they tend to have a very specific view about how they want the states to handle it. But yeah, Scalia says, based on Bowers, so it's rational to criminalize the conduct. Surely it should be rational to deny special favor and protection to those with a self-avowed tendency or desire to engage in the conduct. So yeah, that's basically his main point, that Bowers can't really coexist with this decision. And of course, Bowers ends up getting overturned later in 2003 in Lawrence versus Texas. And Scalia, of course, dissents again in that case. And then he dissents again in Obergefell versus Hodges. So, yeah, that is Romer versus Evans for you. I hope that you found this helpful. I hope that it'll help you get an A plus in whatever law school class you're reading it for. Or I hope that if you just were watching this for your own interest, that you found it interesting. And if so, please leave a like, comment, or subscribe. I would really appreciate it. It helps grow the channel. And I will speak to you in the next video. Thank you for watching.